Viewers, welcome back to the Personal Injury Law Show. And it's that time of the show where we've got Kathy's mailbag. Good evening, Kathy.
Good evening, Tony. Good evening, viewers. And good evening to our special guest, Carolyn. Welcome to the mailbag.
We had a bit of a dry segment talking about costs.
Yes, that's why I'm here now.
But I'll tell you one thing, it's not dry for the simple fact that if we get it wrong, or if a lawyer gets it wrong and a plaintiff gets it wrong, what it's going to cost them will probably outweigh the benefit of lodging a claim in the first place.
Absolutely.
Isn't that right?
Absolutely. Whilst it does come across a little bit dry at times, it's so imperative in the nature of work we do, and we have to get it right.
Because a lot of pain and suffering claims aren't worth big dollars, are they?
No, especially if you're, in fact, much older worker. But even so, the pecuniary loss is very significant, and you don't want to be giving that up in a hurry.
Yeah, that's a good point. Kathy.
Great. Well, let's go on to our questions for tonight, and we've got Carolyn to be able to assist in answering them. So, viewers, you're very lucky. Our first question is from Lucinda from Newport. DPI show. I work as a nurse at a major Melbourne hospital. Nursing can be very physical at times. When I was younger, this never caused me a problem. However, in recent years, I have been struggling with some of the more physical tasks, like helping patients in and out of bed and the bath. I've told my boss about this before, but she doesn't take any notice. The other day I was helping a patient who had fallen, and as I was helping them off the floor, I felt something go in my back. Now I can't make it to work each day without taking a bunch of pain relief medication. Do you think I have a claim against the hospital? And how serious do my injuries need to be before I'm entitled to compensation? Now, Carolyn, I'm going to take this right to you. This is very familiar in my opinion, but I'm going to let you answer this for Lucinda. So,
okay.
What are your thoughts?
Well, Lucinda, we get a lot of claims from nurses like yourself. Clearly you have suffered an injury arising out of employment, and the first thing I would do is go and see your GP and lodge a work cover claim. You can do that within 30 days of realising that you've got an injury. You shouldn't leave it more than longer than that. Also, it's probably not a good idea for you to even be at work unless you're certified fit by your doctor, because you could be further injuring yourself. That is a significant issue. So you should be putting in a claim. It has to be decided within the Work Cover Authority within 30 days. If you get accepted, and there's no suggestion to be that you wouldn't be accepted, then you get 95% of your pre-average weekly earnings for the first 13 weeks. Then it drops down to 80%. And you get that for the whole period that you're certified unfit to do your pre-injury duties. And of
significance, Carolyn, is they get their medical treatment paid.
That's right. So, in fact, if you need to go and see a surgeon, if your doctor refers you off to a specialist, or even before that, to physio, medical treatment, whatever you need, it has to be picked up by work
And Carolyn,
cover.
what you're talking about is no-fault benefits. The next step is if the injury is serious, at law, which is what we were talking about before.
Absolutely. Well, it may well be, and I do hope this isn't the case for you, Lucinda, is that you've got an ongoing problem and you might not be able to return to nursing in any capacity, or if you can, only just light duties. Particularly if you're an older person, and I pick from what you've said here that you were able to manage in your earlier days, so that suggests to me that you're a bit older. Now, if you do have a common law claim, you can pursue that about after 18 months. The idea being that you have to be fully stable, you have to meet what's called the serious injury test, which means that the consequences for you have to be more than marked or considerable, or at least very significant. You can, as I said, you can do that after 18 months of suffering your injury, and you would need lawyers to help you with that process.
Without that, not after the way the law's go.
Yes.
The changes has made it absolutely imperative.
Absolutely. But I was going to say too is that you've picked up an important point, that the employer has failed to take into account what you've said about the nature of your duties. I'm very aware that nursing carries with it a lot of risks, but there are clear ways that the employer can avoid that happening.
There's hoist too now, isn't there, Carolyn?
There's hoist, there's lifting devices.
That's
you have
right.
to be doing the job with another colleague as well. WorkSafe give out very clear guidelines on how this should be done. Now,
so negligence is good in this case.
If the employer has failed to do any of that, then
That's
you've
right.
got a right to sue for damages.
That's very, very detailed answer, Carolyn. Very
Thank you.
I thought that was great.
I think the
Lucinda's very lucky.
I'd get some legal advice on that one. It's a good case.
Speak to Carolyn. We've got to move on to our second question for tonight. It comes from Pete, who's in Werribee. DPI show. 3 months ago, my boss asked me to lift some timber at a work site where I was based for a few months. I'm experienced enough to know better, but we were in a hurry, and to be honest, I didn't want to look weak in front of my mates. So I picked up the wood on my own and immediately felt something snap in my shoulder. I went to the hospital and they gave me pain relief, and since then I've been seeing a physio. The problem is that from my point of view, it's getting worse, not better. It makes it hard for me to go to work some days. Am I entitled to anything under work cover? Tony, would you like to start this off? I mean, not good for Pete.
No, it looks like he could have snapped his supraspinatus tendon by the sounds of things, but sounds to me, follow Carolyn's advice in the last viewer's question. Lodge a claim, get a certificate, lodge a claim, get it processed, you get your medical treatment paid for, you get loss of income paid for, and if it turns out to be serious, and usually when you've snapped something in your shoulder, chances are it is serious.
Especially if you're a labourer and you can't really do that job anymore, it can have serious consequences.
Oh, for sure. This is one where, in my mind, there's no doubt there's going to be a serious injury for pain and suffering.
Yes.
An issue is going to be whether there's echo loss attached to it. And with shoulder injuries, it's very hard to assess. You've got to see how you go and basically, like you said, Carolyn, can they do light work, or is he a heavy worker? And age kicks in again. That was a very valid point, what you said.
Thank you, Tony.
So, what do you think of liability on that front, in terms of the fact that he knew that he should have actually had two people, well, more than one person assisting him?
Well, he says, I'm experienced enough to know, but we were in a hurry. Now, he could have been put under a lot of pressure by his boss to get things done quickly. He's had to cut corners. And for a lot of workers, if they don't do as their boss tells them, they can get sacked. Yeah,
that's right.
So liability is good. There might be something come off contributory negligence, perhaps. I doubt it, or who knows? Well,
given that he was inexperienced and he probably should have said something, but that won't defeat his claim.
Okay.
All right.
Well, we've got one more quick question.
Good advice. Yep.
That's right. One more quick question. DPI show. I watch a show every week and always hear you guys on the radio. I know you have a no-win, no-charge policy and was hoping you could explain a bit about how that works. Firstly, this comes from Mike in Vermont South, and thank you for watching our show.
I'll be very brief. If we lodge a claim for you and if you win, we get paid. If you don't win, through no fault of your own, we won't get paid. But if by any chance your claim fails because you've been caught out on video or you're doing the wrong thing, the no win, no charge policy doesn't apply. And all practices in this area of law work on the same basis. So, yeah, that's how it works.
Okay, well, thank you very much. We hope that's helped Mike. Viewers, thank you again for writing in, and please keep writing in to us. Our email address is info@thepishow.com, and also catch up on earlier episodes at www.thepishow.com. Thank you, Carolyn, for coming to answer our questions tonight.
It's fun.
Thanks, Kathy. Carolyn, thanks for joining us tonight.
Thank you.
Viewers, thanks for watching. Stay tuned, and we'll see you next week. And stay safe. Thank you.